Thank you, Manny. Hi, everyone. How's everyone doing today? Excellent. Oh, I see a friend. I see lots of faces I know. Hi, everyone. And not just my friends. Hi, everyone. You're all my friends now, actually. I'm seeing more faces I know. Um, Thank you all so much for coming out today because there's so many other places that you can be on a beautiful day like today, but you are here participating and learning and getting the resources that you need, that we all need. We are recording this session so that we will be able to put it up on our website as we do with we're working to do with all of our Manhattan Empowerment Series discussions. I have to say several thank yous before I say a couple of remarks. First, of course, thank you to Manny and his entire team, Junior, I'll tell you more about the constituent service team in a moment, but I want to thank our yes, thank you. Applause for our constituent service team for not just waiting for constituents to come in to ask questions, but for creating forums and opportunities for constituents to get the information kind of wholesale. So Manny and his team have come up with this idea, the Manhattan Empowerment Series, which is creating an opportunity for us to share experts and their information wholesale so that you can always plug in, whether it's in person right now or online to get some of the answers to the questions that you need. So thank you to Manny, thank you to Junior, Xavier, Lori, Kavina, Tia. Can you guys always wave your hands, please? Dice? I got everybody. That is our whole team. That's the constituent services team. They can help with questions like housing, public benefits, healthcare, any tax questions, education, immigration, public safety, lots of different questions. Their contact information, well, they're all here, so you can see them here in the room. But also, obviously, you can contact them at our phone number, which is 212-531-1609, and by emailing us at info@manhattanbp.nyc.gov, or coming to either one of our offices, either in the David Dinkins building at 1 Center Street or on 125th Street. Thank you to you all for putting this together. Thank you also to CUNY School of Law, Community Legal Resource Network. We will be hearing from Nicholas Edelson in just a moment, and also to Aaron Sanders and the Grand Street Settlement for bringing the expertise. We're really excited about partnering with CUNY to bring all these resources because this is what our folks need, and then also physically being able to do it here, obviously at Grand Street Settlement. So with that, I will just say one last thing about us and the borough president, Mark Levine. He has a long-standing relationship and history, if you will, around advocacy, particularly with regard to tenants' rights. He was the sponsor of the first legislation in the country for tenants to have rights to have an automatic right to counsel with regard to whether or not they would be evicted from their homes. And it was working, and we were seeing evictions going down pre-pandemic. The pandemic changed everything in terms of how our court system is running, frankly. And we are trying to get back to the norms that had been established by that legislation. We need more funding. Thank you. Need more funding for the right to counsel programs so that tenants can have the legal assistance that they need. But the law is on the books, and it actually spread throughout the nation. In addition to fighting for tenants' rights, he also, as many of you know, and has already been referenced, has really been an advocate for affordable housing. There are several reports on our website that I encourage you to go through. I don't want to take too much time, but I encourage you to go check out our website because there's several reports on our website around housing and the need for affordable housing and the policy solutions to make be able to build more housing in New York City, because we have a 1.4% vacancy rate, which is what is driving the rents to be too damn high, excuse my French, but all of y'all know the reference. Everybody in the country knows the reference. So please check out our website, not only for for more information about the work that we're doing around affordable housing, but also to see other discussions like this. And with that, I thank all of you for being here. I thank everyone who has been a part of putting this fantastic event together. And I will pass Manny, not Mike. Manny, am I handing straight off Excellent. All right. Well, then we have our amazing presenter from NYU School of Law's Community Legal Resource Network, Nicholas Edelson, who's going to take the realm now. Thank you so much. Thank you, Nicholas.
Thank you. So my name's Nicholas Edelson. I'm an attorney. I've been practicing for about 20 years. During that time, I've done a lot of landlord-tenant law, but I also do litigation related to other things about property and estates and that sort of thing. And I did a lot of foreclosure defense at one time. I've given a few of these talks on other things. This is the first time I've actually done probably the thing I'm most qualified for, which is landlord-tenant. But I want to point out one thing, is this is an informational session. I'd be happy to tell you whatever if you have individual questions, I can try to answer them. But I cannot practice law to 25 people at the same time, right? So this is not the practice of law. This is information. And if you have a particular case, especially a particular case where you are in court, headed to court, or you're in contact with an attorney from a landlord, you really need to do everything you can to talk to an attorney. If you want to, I can try to consult with you quickly after this, or whatever it is you can do. This is, your case then is at a point where it's a little bit higher level than what I can do here. Happy to do what I can, but you're in a different place then, okay? Another thing, I used to live in the neighborhood. I lived not far from here on the Lower East Side, a couple different places. And my landlord actually went to prison for attempting to assassinate one of his tenants. Yes, this is a true story. He tried to employ a local drug dealer to kill one of his tenants who was not paying the rent. And he went to prison for like 17 years. It was in the news. He didn't succeed, Guy was wearing a wire, careful who you partner with. And he went to prison. Okay. So we're going to start with just the basics. I gave out what is essentially an outline of everything I'm going to tell you, and you can follow along here, make notes or questions, but it'll tell you the outline of what I'm going to do anyway. So later on, if you're like, what was he talking about? What was that second kind of tenancy thing? Hopefully you can look here and remember, okay? No. Okay, there's two different kinds of tenancies, major kinds. There's rent-regulated and non-rent-regulated, also known as market rate. Okay, rent-regulated, usually you'll hear the word rent-stabilized. The rent is only allowed to increase as determined by the Rent Guidelines Board. 9 members of the Rent Guidelines Board are appointed by the mayor, and it'll go up by 3, 4, 5, 6%, depending on what's going on. 6 would be very high. There are some years when it hasn't gone up at all, but this is the thing that most people think about when they think rent stabilization, is that their rent the amount it's allowed to increase is regulated by the Rent Guidelines Board, which is good. Obviously, if you live there, that's the way you experience rent regulation on the most direct basis. But from a legal standpoint, it's actually not what I think of as the most important thing. The most important thing to me, if you're rent stabilized, is you can't be evicted like that. It's very hard to evict someone who's rent stabilized. If you not rent stabilized, if you just have a regular lease, when your lease is up, in theory at least, the landlord can say, I'm sorry, we're done. I don't want you here anymore, you have to leave. Now, it's not that easy for them to actually make that happen, but theoretically they can do that. When you're rent stabilized, they have to offer you a lease renewal, which changes the relationship between you and the landlord quite a bit. And so that's, to me, from a legal standpoint, that's what's really, really important about being rent stabilized. There's another kind of rent regulation, covers sort of 2 different categories. Rent stabilization is the major one. And you also hear sometimes people talk about rent controlled. Rent control is another category of rent stabilization, but it's a much, much rarer state. Basically, rent control is only if you've been in your apartment since 1973 until now, or you may have succeeded to someone else who started with when they had their lease in 1973, maybe your parents, or you married someone who had a rent-regulated apartment, or your brother had it from your parents and then you got it from your brother. You can keep succeeding to it as long as you have a close familial relationship with that person who is on the lease, and you live with them continuously for a couple years. That can happen in rent-regulated apartments, rent-stabilized, and rent-controlled. But because of that limitation on rent-controlled, once the person who is the rent-controlled tenant moves out, it's not rent-controlled anymore. Rent stabilization, you move out, it's still a rent-stabilized apartment. So rent control is pretty rare. And rent control, when you hear sometimes these stories of these people with like $500 rent for like a 2, 3, bedroom apartment, that's usually rent control, and it's pretty rare. Most of the time what we're talking about is rent stabilization. Rent stabilization also starts in 1973, and it continues till now. And there is another category of rent stabilization for new construction, where in order to get tax breaks, they create a certain number of rent stabilized units in new construction. But for most people that I talk to, most of the time, if it's rent stabilization, they got the old-fashioned kind. A building if it had 6 or more units and it was built before 1973, it's supposed to still be rent stabilized. Now, some units get taken away from rent stabilization over the years, so it's not automatic that you will be. If you're not sure, your lease should declare whenever you get a renewal, it is or it is not rent stabilized. If you're not sure, which usually means you're suspicious that your landlord is pulling a fast one and your rent is rent stabilized, they're not admitting it, you can find out by calling the Department of Housing and Community Renewal, and I put a phone number on here for that under D. Generally, buildings with 6 or more units built before 73 are regulated to see if you're rent stabilized. Call the New York State Division of Housing and Community Renewal, and there's the phone number, okay? We talked about succession rights already. Unregulated or market rent, no rent increase protection. And that's what people think about when they think, oh, you're market rate. And of course, if you're market rate, that means your landlord can raise the rent to whatever they want. They could raise it to $10,000 a month. Yes, they can do that. You don't have to pay it, but they can claim it. And if you say, I won't agree to that, you're not signing that lease, you don't have to agree to it. But there's nothing to limit the amount. There's no law that causes them not to increase the rent. There's some new regulations about good faith reasons for evicting people even if they're not stabilized, but that hasn't really been tested in the courts yet, so I'm not really going to speak to that. The general rule is market rate. They can charge whatever they want, and when your lease is up, they can ask you to leave, okay? It doesn't matter how long you've lived there. A lot of people think if you live there long enough, somehow they can't raise the rent that much. It's not true. If your market rate, they can raise it to whatever they want, okay? Okay, public housing, NYCHA. NYCHA is really I said there are 2 main categories. This would be a third one, but I'm not really going to dwell too much on it. The truth is that NYCHA is kind of its own animal, you know? It's very hard to get protection if you're a tenant in a NYCHA housing development, because NYCHA has kind of its own court system to handle their cases. They have a hearing room. I have done them. They have a hearing room. It's down here on Broadway where they have hearings, which is kind of like having a little trial on whatever issue it is. And then they have an actual courtroom where cases that are tried in courtrooms. It is their own courtroom because they have their own judge and their own lawyers. It's not like regular housing court. And as you can imagine, it's very hard to win there if you're on the tenant side. You're basically dealing with a situation where part of the government is the landlord, and the government is making the rules for the courts and for the system, and they're not tenant-friendly. Now, lots of other parts of the government and other politicians are putting a lot of pressure on NYCHA to straighten up and fly right, especially around repair issues. There's been a lot of action about that lately. It seemed like there was some progress made. I was really happy to see that. But it's just really tough to win against NYCHA. It's really a political problem more than a legal problem. I will say I have won a case or 2 against them, but it's really hard. Okay. Communicating with your landlord. Okay, whenever you're going to communicate with your landlord about anything that's going on, you really want to try and do it in writing if at all possible, for a lot of different reasons, and that'll come up again later on. But if you don't have a physical address that you send your rent to, or they don't give you an email, like this, I've seen this many times. It's a little bit less now. I have to say things have gotten a little better. Landlords who there's a phone number to call the management office, and they don't answer the phone. And that's all you got. You don't have any other way of communicating with them. And they'll set up like an automatic bill pay, so you don't even have an address where you're sending your rent, and there's no way to communicate with them. But there is a way. On your lease, there's going to be an address for the landlord. It may not be what you think of as the address for the landlord, because you may have that their management office is on 4th Street, and there's an address out in Long Island City, Queens somewhere for the landlord that's on your lease. So you don't think that's your landlord, but that's your landlord. And if you need to send something to your landlord, you send it to that address. And if you don't have that, or there's some other reason you mistrust it, you can look up any building on ACRIS online. Now that's, I could spend 20 minutes trying to tell you about ACRIS, but if you can't figure it out, it can be figured out. I don't want to get too far into it. Can I help you? It's on the form here. It's spelled ACRIS, all capitals. It stands for something. It's number 5. We're on number 5, communicating with the landlord. There's a handout that you can get a copy of, okay? Yeah, you got to communicate with your landlord in writing if at all possible. Especially if, I mean, if everything's cool and you can call up and say, hey, you know, my light's not working in my bathroom, and the super trots over and fixes it, then you don't have to do anything. But if you're having an issue, if that's the case, you know what, you didn't come to me. Like, I never heard that story, because nobody ever went to a lawyer and said, hey, every time I call my super, he fixes it up, no problem. My experience is always a problem. So I'm a little bit jaded, you know? If everything worked out, the lawyer doesn't know about it. So in my experience, I always tell people, communicate in writing whatever you're going to do. So you have a complaint about something, write about it in an email, put it in a letter, sign it, date it's very important. Emails are dated automatically, which is great, but if you send a notice in that says, hey, my bathroom ceiling's falling down, again, like I keep telling you, come fix it, and you didn't date it, and you end up in court, they're going to say, that letter's from 10 years ago. No, it's from last week. Why didn't you date it? You got to date it, okay? You're going to make you're always building your trail of evidence, hopefully that you will never need it. Like, they're going to know, oh, she signed it, she dated it. Now we have evidence that she told us. It's going to be hard for them to later say, we didn't know your ceiling was falling down. So that's why you got to sign and date everything, okay? Okay, common tenant complaints. The most common, I do this, I should tell you, another thing I do, I provide like a free limited legal services. I've been doing this for 18 years. People come and meet with me in various places, and I don't represent them in ongoing ways, right? They come to me and I have an hour, maybe see them for a couple hours later on to try to solve their problem. And I've been doing this for 18 years. So I see certain complaints a lot. The most common complaint I hear is noise. Noise, usually from the upstairs. And this is a problem. This is a landlord-tenant issue. This is not, in my mind, legally, this is not an issue between you and the person upstairs. The person upstairs doesn't have a legal relationship to you. They don't have a legal obligation to you. Your landlord has a legal obligation to provide you with the use and quiet enjoyment of your apartment. And if the person upstairs is dropping weights at 4 in the morning, then the landlord is breaking his obligation to you, because the landlord has to make them stop. You can't make them stop. So it's a difficult problem to fix, but it is the most common. There'll be noise complaints from people upstairs. Usually it's people from upstairs. And what you have to do is send those letters to the landlord, sign them and date them about what happened, and be as specific as possible. And ultimately what would happen is the landlord would, in theory, take that person to court for breaking the lease, because their lease says you can't interfere with the use of other people's quiet enjoyment of their apartments. So now that landlord is going to sue that person for breach of the lease and say, you got to stop this or move out. And now you're in court complaining about noise. Guess who doesn't want to evict anybody for making too much noise? The judge. So the judge does not want to evict anybody for this. Does the landlord want to bring this case? No. When the landlord wins this case, do they get any money? No. Do the landlords cost them money? Yes, they got to hire an attorney to go sue that person out. The landlord doesn't want this case, but they'll take it if things get bad enough. You sometimes have to get to the point where you threaten to withhold rent because you say, hey, landlord, you broke the lease. You're breaking the lease, I'm not going to pay you. How'd you break the lease? You letting this noise complaint go. The judge doesn't love that either, but at least it's a defense. If they then sue you for non-payment of the rent, you can say, hey, he broke the lease first, and here's my proof. Here's my email. Here's the email, the letter, like that lawyer told me. I signed it and dated. Here it is, Your Honor. I've been complaining about this, and they're not doing nothing. So now, hopefully, the landlord is sending letters or taking action against that person who's making too much noise. And what are you really going to have? It's mostly likely you're not going to evict the person. Unfortunately, sometimes the person making all that noise has a mental health issue. This is really tough. I'm not going to lie to you. This is really tough because the court doesn't want to make a mentally ill person homeless either. And the mentally ill person does not respond very well to letters from landlords saying, hey, you got to straighten up and fly right. But in theory, down the line, this is the way it plays out. Then they send them notices, you got to stop this, and they stop making it, or or they agree to put down carpeting, padded carpeting, or doing some kind of measures to reduce the noise. That's the way those issues get resolved, okay? A noise is considered a nuisance. Another form of nuisance that's kind of, the law about noise comes from the similar ideas as when someone's making noxious odors. You know, they're smoking something they shouldn't be smoking, or they're making something in their apartment, like little manufacturers, and they've got some kind of burning oil smell. Anything that creates an odor or noise or something that really interferes with other people's peace of their apartment, that's a nuisance. And so it all falls under the same category. Okay, repairs. This is the next most common issue, is a repair issue. It is very important that you write written notice to the landlord of repair issues and that you give written notice of access dates for repairs to be made. Okay, so I know I keep saying written notice, I'm going to keep saying written notice. Get used to it, I'm going to keep saying it. Okay, so why for this is it so important? If you don't give them written notice that the bathroom ceiling is falling down, it's a very common complaint. You know, there are lots of other things. You know, some kind of leak, wherever there's plumbing, that's common. You get a leak, then the ceiling is deteriorating, it's falling down, there's mold, it's in your bathroom, it's horrible, you can't use your bathroom half the time, or you're embarrassed to have anybody come to your house. Okay, written notice to the landlord, you got to tell them what it is, and you got to sign it and date it. Because if you don't, and you ever end up further down the line, like let's say you stop paying rent because you're like, he's not doing repairs, he's not keeping his end of the bargain, I'm not keeping mine. We're going to court. And then you get to court and you say, you know, Your Honor, I didn't pay the rent because my bathroom ceiling's falling down. He's not taking care of it. You know what the landlord's going to say? We didn't know. You didn't tell us. You got to have it in writing, okay? The super came 3 times. Super's not going to be in the court to say, we didn't know. The landlord's attorney is going to be there and say, we have no written notice that this was the existence. He's not even going to say he doesn't know. He's going to say, we don't have written notice, Your Honor. Okay? Hang on. So you need that. Now, the next part of that is also access. So a claim of ignorance by landlord is the #1 defense against a repair claim. The #2 is access. We came to fix it, Your Honor, and they weren't there to open the door. They wouldn't let us fix it. So you want to give written notice. Here are 3 days you can come. Here are the times when you can come. If these are not acceptable, call me and I'll make alternative arrangements. No reasonable arrangement will be denied. You can't give them, 1 hour on Thursday and 1 hour. You've got to be a little more broad than that, or they'll say we couldn't do it at that time. But that's the second thing they're going to claim. We didn't have written notice, and we didn't get access to do the repair. Here. Okay. Harassment. A lot of people see landlords as being engaged in harassment against them. There is some special laws regarding harassment, protections for tenants, but they're kind of weak. I'm going to tell you this. Harassment outside of housing court means something like, you got threatened by someone, they said some abusive, obnoxious things to you, maybe they showed up at your job and started ranting and raving at you and embarrassing you and threatening your job security. That's like harassment, and you go to the police for that. And usually that's a family court matter because it's usually husband, wife, boyfriend, girlfriend, sisters, it's usually a family matter. And what you want is a stay-away order, an order of protection that says someone has to stay away from you. That's normal harassment, not housing court harassment. In housing court, there's a new law that's supposed to protect tenants from harassment. It's really very narrow. It really only applies to a situation where the landlord has been bringing repeated baseless eviction claims against you. That is harassment. But you got to win a bunch of those cases before it'll add up to harassment. Okay? Having it happen one case isn't harassment. It's going to take 3. Overcharging. If you live in a rent-stabilized apartment and they've overcharged you on the rent, you can theoretically get triple damages for every penny that they overcharged you. But that's where that calling DHCR and getting your rent history is going to come into play. Now, this was intended to keep the landlords from overcharging people, and I think that it actually has done a pretty good job. But there's a lot of loopholes that have kind of emerged. Basically, if the landlord says, we didn't know that we were overcharging you, then you'll get whatever they overcharged you back, but you won't get the triple damages. And usually that happens when there's a change in landlord. So the new landlord came in and said, we thought 800 was legal because that's what they told us. And it turns out your legal rent was only 600. Now they've been overcharging you 200 bucks for 3 or 4 years. They're going to claim we didn't know. And they may be able to get away with that. But not necessarily. It's just not as simple yes or no. If you've got a chance to get that triple damages, you want it. Even if you don't get triple damages, if it turns out they've been overcharging you for 3 years by $200 a month, that's a lot of money. You want to get that money. Often those triple damages cases get settled with a landlord that goes, uh-oh, I could end up owing you $30,000. Will you take 15 and we'll call it square? You know, because they don't want to take the risk. So now the particular harassment statute I'm talking about is geared towards baseless lawsuits or proceedings by the landlord against the tenant, and that's a form of harassment. If there's another form of harassment, the kind I described as non-landlord, your landlord could be harassing you in a way that would apply that isn't protected by housing court. And then you can't take that claim into housing court because the judge there is going to say, this really has nothing to do with your tenancy. This person's been threatening your life or putting stuff in your mailbox or doing whatever. That's a criminal act, potentially. So you need to go to your local precinct and start making complaints. Harassment where they're making threats against you, maybe they're damaging your door, putting things under your door, this kind of stuff. Even though it's a landlord-tenant relationship, the violation there is a violation of a criminal statute of harassment. I hate to say this also, unless it gets really bad, like really bad threats of violence and maybe some overtly threatening behavior, like pounding on your door at 4 a.m. and saying F you and da-da-da-da-da, the cops are not probably going to respond much, in my experience. Okay, cops hate harassment claims.
As far as the stabilized lease, you're supposed to get a lease. One of the benefits you said is that you get a lease. You're supposed to have a lease, right? And if you're not given a lease, and if the old lease expires, and they keep giving you an invoice that corresponds with the last lease, and that goes on for months and months, this is the landlord.
Lucky you. You're paying the old rent.
Okay, but when they figure this out and they offer you a lease, what is that lease going to be based on? That new lease?
Well, they should not try to retroactively say, there was a 4% increase and you didn't pay it for 6 months and now we want it. They're not supposed to do that, but they usually will. So then you have to say to them, you didn't offer me a new lease. That means the old lease was in effect until you offered me a new one, so I didn't have to pay the increase until you offered me the new one. They're not going to go, oh, sure, thanks. Sorry, here's some flowers. They're not going to do that. Landlords don't usually admit they did something wrong. But if they press you to pay it, you have an excellent defense, as long as the evidence is square. And then they're going to say, they could end up saying, no, we did send you the lease back when such and such happened. But they're not going to have the evidence that they sent you the lease.
Well, what if the chain is broken now with the new lease? Because the last lease corresponds to, there's a period of time there's no real lease.
No, there is. That's what I'm trying to tell you. There is. The old lease remains in effect until you get the new one. That's the real power of rent stabilization, is that old lease, if they didn't give you a new one, the old one remains in effect. And the new one is going to be shaped by the increases that are allowed by the board. So if it's a 4% increase, that's all they can do. And otherwise, they can't add or they can't take anything away from you in the new lease. They can't say, for instance, you had an air conditioner that was included, say, oh, we're going to take your air conditioner. That air conditioner was in there and you were paying for it. You're paying for that until I leave. So they can't take anything away from you with a new lease. Okay, and they have to give you a new lease. Okay. Okay, claims of back rent that are owed that are not true, you got to keep a good record. If they only accept cash, get receipts. If they refuse to give you a receipt, don't pay them. If they don't give you a receipt and they only take cash, stop paying them. Tell them, I'm not paying until you give me a receipt. Now, if you have rent-stabilized apartment, that you are definitely going to win that battle. If you have a market rate apartment, there's a lot of vulnerabilities to market rate, which is that basically, if they say you have to pay cash and we don't want to give you a receipt, and you say, no, I'm not going to do that, they could say, we're not going to give you a new lease. Now, can they really do that? Because legally they are supposed to give you a receipt. They shouldn't do that. That would be considered retaliatory eviction by but the reality is, if you're market rate and the landlord doesn't want to renew your lease, They don't have to. The reality is also that evicting someone, even in a market rate apartment or whatever, is a long, expensive, and difficult process for the landlord. So don't be afraid to stand up for your rights up to a certain point. But there is, just common sense is if you're really antagonizing your landlord and they really don't like the way you're behaving, they're not going to renew your lease, and that's going to be a problem. Okay, so if the landlord refuses to accept your rent, but you're trying to pay it, the question is quickly, why are they doing that? If they're going to claim that you didn't pay, and yet you have something in writing from them saying they're not accepting your payments, then that's not going to fly. It's not going to fly that they're saying you're not paying. They're not accepting your rent. That's usually a step that they're taking where they're saying, you've broken the lease, or your lease is over, and we're going to evict you. And that's a holdover case, which we're about to get to. That means you're holding over past the end of the lease. Now, if you're rent stabilized, a holdover is really tough to win. The only things that you can really win on a holdover are things like you're a non-resident. So like it's in your name, but you're actually living in Florida, and you're renting it out to someone else. Or an illegal sublet, which is essentially the same thing where you're subletting it to someone else. But an illegal sublet, if the lease is still in effect, so let's say you're on a 2-year lease and you've illegally sublet to someone, and the landlord says, hey, you're bringing a non-residence holdover against you, but the lease is still in effect. They can't do that. They have to bring an illegal sublet and send you a notice to cure, which means you have a chance to fix whatever is wrong. You follow? So if you are subletting illegally and the landlord finds out and they try to evict you, but the lease is still in effect, you haven't got to the point where the lease renewal they have to give you the chance to cure. And to cure, you have to evict that person and move back in yourself. Okay? So whatever it definitely sounds like what they have there is they're preparing for some kind of holdover with you. But I don't know what the holdover is for. Are they claiming your lease is up? Are they claiming you're violating the lease? What are they going to claim? So then we'd have to kind of get into that. It sounds like it's a little specific for what we're talking about here. Although I'll go through a few more holdover things in a minute. We're already into this, right? 2 main types of proceedings, non-payments versus holdovers. On a non-pay, you need to get a 14 notice of non-pay before they can begin the case. So 14 days before they can go to court and begin a case against you, they have to say, you owe us 3 months rent or whatever it is. They got to tell you. All housing proceedings require a predicate notice. This is a notice that must be properly served to you before the landlord can begin the case. So in a non-pay, it's some kind of a 14-day notice that this, so you're going to get all these notices, and to you they may all seem the same, but in the eyes of the law they're very different. Okay, a predicate notice happens before the case begins in court, before the landlord goes to the court and pays to get an index number and has permission to start something in court. And that predicate notice on a non-pay is at least 14 days saying you owe rent. If it's a holdover or they're going to terminate your lease and you've been there for 2 years, they got to give you a notice 90 days before your lease is up saying we're not going to renew your lease and we want you to move out on that date. That's called a predicate notice. That notice has not been seen by the court or the judge at all at that point. They have to do that before they begin the case. Okay? All housing court cases have predicate notices, something they have to do before they can begin the case in court. Okay. If you get a notice of something saying you're going to court, always answer by going to court and tell them you are there to answer. When you go in there, if you haven't been there, there's a place for tenants to go and you can answer. And it's basically filling out a form with some check boxes on it and stuff like that. And I just want to emphasize that nobody likes doing this, but you got to do it. And it's, hundreds of people muddle through it every day. So don't be so scared of doing this that you let it go by. That's the worst thing you can do. You got to show up. Okay, just like I said, there's some things in the back here about how to answer a non-payment petition. We can go through those. There's a bunch of different defenses. Repairs is one of them. But the last one there you'll see is general denial. And general denial means you just deny what the proceeding says. And when you answer, there's a form that you're filling out, and you're putting in your address, and you're going to check some boxes. One of those boxes, the most important box to my mind, is the one that says general denial. General denial means you deny generally everything that they're saying bad about you. So that preserves your other defenses. So you want to make sure you hit that one. you know? And then there are the other things, we can go through those when I get to the end. If we have time, we'll go through and look at some of those. But that's kind of what I'm saying. Like, some answer is better than no answer, and the easiest some answer is general denial. Deny everything they're saying, okay? It's right there on the form, okay? Okay, non-payments are the simplest type of case. One of the first things you're going to do when you go into any case is you're going to ask for an adjournment to get an attorney. After you've answered, you're going to show up in court, and you're going to say, I need time to get an attorney, okay? There are legal services attorneys that are supposed to be there for people who don't have enough money to pay for their own attorneys. There was a rule passed that said that anybody in housing court is supposed to get an attorney, and one should be provided for you, just like in a criminal case. They made a rule, but guess what they didn't do? They didn't make the money to pay for all the new lawyers. So there aren't lawyers for everybody, right? So if you're going to say, hey, everybody who goes in there deserves at least a legal services attorney, and legal services, we have to hire 500 more attorneys for this. Where's the money for 500 more? We don't give you the 500 more attorneys. So it's a contradiction. It's jammed up the system. It is what it is. There are free attorneys for people who can't afford them, but not enough for everyone. And generally, there are, other kinds of categories. If you have economic problems, if you're over a certain age, you kind of have a better shot at getting one. If you have certain kinds of health diagnosis, especially mental health diagnosis, you have a better shot at getting one. So there are free attorneys out there, but there aren't enough for everybody, okay? Another thing you want to make sure if you're in a non-pay is get proof of payments together, like you were talking about over there, right? You want to make sure you have those, whatever it was. Okay, a one-shot deal. One-shot deal, despite its name, does not happen one time. But a one-shot deal in a case, one second, let me just talk about this, I'll get you, okay? So when you're in court and you're behind on your rent, you can apply for a one-shot deal, which comes from HRA, which is the human, essentially through welfare. And it takes time. They're going to look at your economic situation. You have to fill out a lot of forms. You have to show your taxes and all this stuff. And the people that are handling the one-shot deal, there's not enough of them. It's a slow and bureaucratic process. So a lot of times cases that are non-pays will have somebody applying for a one-shot deal, and the case will get adjourned repeatedly for that purpose. So it'll be adjourned for, let's say, 60 days the first time. Come back in 60 days, okay, what's going on with your one shot? Judge wants to know. You say, well, I applied, and they said that I needed this and this, and I gave them that. And then they said I needed this other thing, and then I gave it that, but they haven't responded to that. So basically what you're saying is I'm in the process of applying, and they haven't given me a final answer. If you always want to say it's not a final answer yet. Even if you think they're not going to give it to you, you want to say, they haven't been that clear. And the truth is the one shot, usually they don't say, no, you're not getting one, that's it. They usually will have some more question or some other thing they want you to do. And you may get the sense they're not going to give it to you, but they don't really like to say no way, okay? Then the one shot deal will come in, hopefully it'll pay the back rent for you. And guess who likes this? The landlord, because they got their money, right? Guess who else likes this? You, because you didn't have to pay the back rent. Guess who else likes this? The judge, because they didn't have to evict anybody and they didn't have to have a trial. So everybody likes this, except, the government has to pay the check. And there are limits. You can't get it for any amount of money in the world. One shot will not say, this is the maximum amount of money we will pay. They will not say that. But there is a maximum. They will not pay certain amounts. You go over like $40,000, $50,000, it's very unlikely they're going to pay that. But it's not impossible. Under certain circumstances, they will pay it. During the pandemic, there was all those funds for paying things that kind of got used, and then the one shot would pick up some of the slack on that. So there isn't, it's vague. That's what I'm trying to tell you. It's vague. And the vagueness of the one shot can be used to your advantage because you don't get a hard and fast answer that gets you another adjournment and more time to figure something out. Okay? Okay. Yes. This is an excellent question, actually. Sometimes when you're in the process of applying for the one shot, the landlord will refuse to give you a lease, which the one shot organization needs in order to process your one shot. Because if you don't have a lease, they don't want to give you the one shot. The kind of rule for one shot is that they don't want it to be a two shot. They don't want you to come back in 2 months and say, hey, I can't pay it. They want proof that they want you to show the future ability to pay, so that you had some excuse why you fell behind, and it looks like you'll be able to pay it from now on. But if you don't have a lease, then they think, well, we paid your one shot, but then you got evicted the next month because you don't have a lease. I mean, you have to complain to the court and go to the court. And when you do that, best to have it in writing from one shot saying that they have refused to give the lease. But usually what happens is you had to go to the landlord and say, give me the lease so I can give to the one shot. And the landlord says no. Or the landlord doesn't even answer your question. You just don't get it. And then one shot doesn't answer that either. If you can somehow get it in writing that they're not giving you the one shot. So again, writing letters to the landlord, writing emails to the landlord. Hey, this is the third time I've asked for the lease, and you're not giving me the lease. I need it to process the one shot. Then you show that to the judge. And then hopefully the judge says, well, we got another adjournment here. See if these people will come up with the lease, right? And the adjournments are not bad for you, right? So that's the best way to play that, okay? Okay. Once the rent is paid, the case is over. That means if you came up with the rent, you showed up in court and said, hey, Your Honor, I got the money right here. Here, you know, I'm going to pay it right now. Even if you didn't actually physically have it or you didn't have it, you know, a bank statement that showed you have it, you know, unless you've done that a few times and gotten caught for lying, basically the judge is going to give you like another 24 hours or 78 hours to pay. If the rent gets paid, that's what the, you know, then the judge says, well, this case is over, right? Case done. Repairs as a defense to a non-payment. So when you're in court, if they've got a case against you and they're suing you for the rent, and you say, hey, my bathroom's been falling down, and they haven't fixed it, and here's all the notices I sent, right, Your Honor, here's those written notices I keep talking about, that's a defense to non-pay. It doesn't mean that you don't owe the money. It just means that they can't evict you for the non-payment as long as you have a valid repairs defense. And then what the judge is going to say, okay, you, landlord, fix it. Sorry, I had to make you the landlord, and you are going to pay. And we're going to come back here in 30 days. If you have it, they want you to pay right away because you got the money. And we're going to be back here in 30 days. If they haven't, they're going to make a schedule for repairs, right? And they're going to find what are those reasonable dates for access that we talked about. Hopefully you're writing that right down there in court. And the court's going to order you have to make repairs at these times, right? And you figured it all out. You paid the rent, and then in 30 days, if they haven't made the repairs, you come back with an order to show cause. I know it sucks, but you got to go back to the court and fill out a form that says, you know, and bring the order from the court that says they have to do the repairs. And they didn't do them, Your Honor. Here, they fixed the door, but they didn't fix the window, and they didn't fix the bathroom ceiling falling down, and they didn't fix the wiring. And then you're in court, and the landlord's attorney says, I don't know if they fixed them or not because I didn't, you know, and then they order an inspection. You know, and then the inspector comes, hopefully, and looks at it. Or the landlord attorney comes in and says, well, we did fix some of it. We just didn't finish it. We need some more dates, Your Honor. And usually the court will give them another shot at doing that. But if they don't do the repairs, you might have to go back a few times. If they really don't do them, eventually the judge will hold them in contempt. And that's bad. They could be fined. They could even put them in jail, which they never do. But theoretically, if you're in contempt of court, the judge can fashion their own fashion their own punishment for that, essentially. So usually it's a fine, you know, because they just, you know, but if in theory, if it goes on and on, they could put them in the huskow. Okay, so I mean, if the landlord is so rich and they don't care and they're just trying to harass you out and they've got so many billions of dollars, you know, you just have to kind of show up to court and keep making that complaint. And yeah, it's terrible. They give them the fine for $2,000 and they still don't do the repair. But if they still don't do the repair, you come back the next month and you say, you gave them $2,000. Look, Your Honor, they didn't do anything because they don't care because they're rich as Croesus. You know, do something else, you know. Give them some other kind of order. You know, order them to do it and you know, put them in jail or do what, or make double the fines. Make the fines $2,000 a day for every day they don't do it. You know, the judge can do whatever they want. If the judge is defied enough and it's angry enough, they can do what they want. But it will take repeated attempts. Okay. So mostly what we've been talking about is not condos or co-ops. I'll touch on it now. Do you have a particular question about a condo co-op situation? Okay, well then, maybe I can talk to you afterwards, yeah. Okay. Holdover. What do we got on time here? We're running out of time. Holdover. After the lease is over, that's why it's called a holdover. You broke the lease or the lease is up and you're holding over. I already touched on this. You have 30, 60, and 90-day requirements of notices. So if you've been there less than a year, they've got to give you a 30-day notice that your lease is up and they want you out. If you've been there more than a year but less than 2 years, they got to give you 60-day notice before you to move out. If it's been 2 years or more, they got to give you 90 days to move out. Before they can give, it's 90 days, you have to, so your lease is up in 90 days, they got to give it to you 90 days before then. And they say, this is the date you have to move out. Or let's say your lease expired and they didn't give you a notice beforehand, and now they've decided they don't want you there and they haven't sent you a new lease renewal, they send you a notice that says you have 90 days now to get out. Okay? It's quite a bit of time. And if they mess that up, then their case is no good. Okay? Their case should get thrown out. Holdovers also includes for alleged breaches of the lease, such as an illegal sublet, non-residence, washing machine. I don't know if anybody has that, but I've had a couple of those cases where like the lease says you can't have a washing machine. Okay, I'll wrap up pretty quick here. If you have a washing machine and the landlord says that's a breach of the lease, you've broken the lease, and in breaking the lease is over, and therefore you're holding over after the lease. But that is actually something that's curable. And I talked on notice to cure for the illegal sublet. Basically, they have to tell you, you have to fix this or we're going to evict you. And then you can just take the washing machine out. And now you've cured the breach, right? So now they can't evict you. And there's lots of other holdovers like that. They're too numerous to spell out. It's going to depend on the nature of the lease, but it'll be violating a piece of the lease, okay? I already touched on this. Unless you have an attorney already on the court date, ask for time to get one. There's information in the court about getting a free attorney through legal services if you cannot afford one, but there are not enough attorneys. Okay, HP action. This is the kind of tenant strikes back action here where you take them to court for repairs. Someone mentioned on that. It's kind of rare, but it's good to know that it's out there, okay? For repairs only. There are forms in the courthouse for filing these types of proceedings. It's best to have reported the repairs to the city and have violations by calling 311. So if you got a bunch of violations, you want to report them to the city, because first you're going to say, hey, landlord, here's the violation, here's a repair, fix it. Then they don't fix it. Then you call, repeat, you give them a couple shots at it, you give them written notice. They still don't do it. Then you call 311 and say, I've got to report these violations, come and inspect them and issue violations. The inspector comes from the city. They issue a violation to the landlord. Now you're in a good position to begin an HP action. Usually this is going to be for a lot of repairs. It's not going to be for like one or two little things. It's usually like the whole building is being abused or neglected. A lot of times it's not just your space, but it's like the common area, like the intercoms don't work or the back door is open. So those are safety violations that tend to be taken very seriously. But there are rats in the building, any kind of infestation like that is also taken seriously. Then you take them to court after you get the violations issued. You fill out these forms. And what is supposed to happen is HPD, Housing Buildings Department, is supposed to take a look at the violations. And if they agree that they're serious enough, they will come and be part of the case with you. And they're there to enforce the building code. They're not really they're not really linked arm in arm with you because they're not trying to help you. They're trying to enforce the building code. But if your concern is with repairs, who cares why they're there? They're trying to force the landlord to abide by the building code. So when it works well, you essentially have the city as your partner against the landlord to force them to do repairs. And when they don't do them, HP will do them themselves. They'll hire contractors to come and do the repairs, and then they'll send the bill to the landlord. And the landlord doesn't pay them, they'll become liens on the property. So that's the way it's supposed to work. I think in recent years it hasn't worked quite so well. It just doesn't seem like HP has been as aggressive as they were when the law first came out, but it is possible to do this. It is the landlord's way of striking back against it is the tenant's way of striking back against a landlord who refuses to take care of the building and the property. These things also work really well when the whole building gets organized. If it's multiple things, it's much more likely to be successful. You may have to do a tenants organization, but you don't really need to have a tenants organization, but you could do it that way. But especially if they are violations in the common areas like the ones I described, you get a lot of traction with that. Any- Okay, it's actually, there's actually two different acronyms. That's why it's super confusing. It's an HP, which is housing proceeding. That sounds like they're all housing proceedings, aren't they? No. The one where just think of it this way, the tenant against the landlord for repairs. So it's HP is the name of the kind of action, but a lot of times it's called, make sure I get this right, HBD, because HBD is the city agency that's supposed to enforce the building code. So in the HP action, HPD comes in with the tenant against the landlord. So you'll hear both terms used, okay? But technically it's HP, housing proceeding. No, yeah. HPD is really the people that are supposed to come and do the evaluations for repairs. But when you actually want to begin a HP action, you can contact them before you start. But really, it's the vision of this was that you begin the case in court, and then HPD would be notified after that. Okay. Okay. Eviction. I've got to move along here. If you lose the case or agree to surrender possession, the court will issue a warrant of eviction. The landlord must then go to the marshal to evict you. So the warrant from the court doesn't mean you absolutely had to move out, because the judge doesn't show up and say, pack your things, right? They got to get the marshal to come. And after that warrant is issued, it depends on how busy the marshals are, but it's usually weeks or more after the warrant's been issued before the marshal comes to your door. And when the marshal comes to your door, they put a notice on your door saying you're going to get, depending on whether they gave it to you in person or they just stuck it on the door, it's going to be 4 to 6 days where you have business days before you have to move out. And during that time, you want to truck on down to court with an order to show cause saying, Your Honor, I need some more time to move out, and whatever, you want to show them that you've made efforts to find a place. This is something that could have covered earlier. If you have to find another place to move out and a holdover or whatever, you want to show effort. So if you've got a lease, even if you didn't sign it, you say, here's the lease, they sent me the lease, I'm in the process of applying to get a place. You want to show evidence that you're looking for a place. So if you've got a notice of eviction, you're saying, Your Honor, in the interest of justice, don't throw me out on the street. I'm trying really hard. I've got an application, and these guys said that they're going to give me the place, but I can't move in yet. Okay? You follow? I think I'm done here, but thanks, guys.
Ooh. Round of applause. Thank you very much. That is the end of our workshop for today. I encourage all of you to talk to me and my team for follow-up on some of this stuff. And I want to thank CUNY School of Law. I want to thank the attorney for all of his hard work. And we look forward to seeing you at the next workshop. Thank you. Have a good night.